The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon. A little chilly South Florida. Welcome to another Ask the Experts. Our show is running right now from South Florida. Our expert today is in Central Florida, in the Tampa area. It's one of our hottest shows we have. We're going to be talking about community law, association law, HOA, condo. And this is your chance to speak to an attorney without costing you anything. If you'd like to call into the show, we will have lines open shortly because we've already got people waiting to come on the show. You can also go on our chat box if you have a question for our expert. We're going to have a great show today, and I want to welcome Attorney Kirsten Henza. Hi, Kirsten.
Hi, Steve. Hi, Steve.
So glad to have you. You know, we're gonna open it up to people calling in people's questions that we've gotten since we saw you last month, and we're just gonna have a wonderful show today. But before we get started, we have so many new people finding the show that why don't you tell people who you are and about K. Bender Rimbaum?
Sounds good. Well, hello, everyone who's listening out there. Thanks for joining us this afternoon. Like Steve said, my name is Kirsten Henson. I'm one of the attorneys with the law firm of K. Bender Rimbaum. We represent community associations in the state of Florida. We have multiple offices throughout the state. Our main office is in Pompano Beach, Florida, but we also have offices in Palm Beach, in Orlando, and then an office here in West Coast of Florida. I manage the office that's located here in Tampa, and we represent clients throughout the West Coast. Sarasota, Tampa, so you name it. Yeah.
You know, I just heard the other day that there's some homeowner insurance companies that are getting ready to lower their rates. Did I hear that wrong? Was I dreaming?
I mean, I certainly haven't heard of that, but if you heard that, then that's that's definitely pleasant news.
It's funny. I wish they would have given me the names of the insurance companies, but they said there's two companies that are getting ready to lower their rates, and it couldn't come at a better time.
For sure.
So let's get started. Let's go to our first caller. Hey, caller, are you there?
Hello.
Is our caller? Hello, caller.
Hi, my name is Tony. I'm not sure if I'm on the air or not.
Okay, Tony.
I live on the West Coast, Naples, and I have a question for Kirsten in regards to what do you do if your HOA refuses to hold an annual meeting and elections?
Now, is it that, I'm sorry, did you say are you with a homeowner association under Chapter 720?
Yes.
Now, are they refusing or Or could it be
They-
that they're
they are
holding
re-
it and that there's just no quorum?
No, they're refusing to hold an election. I'll try to keep it as brief as I can. They were in the process of a suit with the builder. The builder claimed that they had voting rights. The HOA is denying them voting rights. Regardless, at this point in time, the builder has no other lots to sell. So in other words, in the 2 years they refused to hold an election, the builder has sold all their lots. The HOA is still refusing to hold an election, stating that the builder is suing the HOA when it was just the opposite way around. The HOA sued the builder with the courts here in Collier County, asking for declaratory rights, stating why they should not hold an election. So the homeowners have had 3 years now without an annual meeting and election, and it comes down to the fact that the HOA just wants to, the current board wants to remain in power. So as a homeowner in this association, what can we do to overcome this?
So has the court already made a determination on that declaratory action?
No, the HOA is not even pressing the issue. They filed this about 1.5 years ago, asking for declaratory relief, and since then they have not brought it to the forefront so the judge can hear it. There is sometime this year in 2024, there should be a court case. In the meantime, they went to non-binding arbitration, and our HOA lost because they filed I forget, something de novo, requesting that there be a trial now. So that means that the non-binding arbitration that they lost, and they have to pay all the fees moving forward. This is just a ploy by the HOA not to hold an election by they asked the court for declaratory relief. They had a meeting last week with the HOA attorney was here, and he claimed just the opposite. He claimed that the builder, which I'm not going to use their name, it's not fair to anybody. He claimed that the builder filed the declaratory relief, and this is why he says the builder can at any time, and he was 100% wrong. The board's attorney was 100% wrong in his statement. We showed all the documents. We actually had a meeting at my house here with about 25 homeowners, and this is where we are. In a nutshell, our HOA this is a 2.5 year lawsuit right now that sometime this year should go to court. Now we missed the 2022. Actually, there was a meeting. There was an election scheduled. The board canceled it a week before. In 2023, they didn't hold an election. 2024, because of the schedule of the courts, they're probably not going to be an election. So now we're looking at 2025. So we as homeowners want to know what our option is when our HOA filed declaratory relief asking if the builder had voting rights, but it's a moot point because the builder has sold all their lots since then. So can you?
Yeah, I mean, it's a little bit of a convoluted situation here, complicated fact pattern. It's unclear if there's been even an election for developer turnover. Do you know if there's even been developer turnover?
This is not the original developer. This is a remaining 111 lots that were remaining from the original builder who pulled out of this community about 7 years ago, 5 to 7 years ago. So this is not the original builder. This is now a new builder that has purchased lots to finish the community, and the only way I could explain it is how I'm explaining it. That there is no legal offering with 720. I mean, we could spend our money and go to arbitration with the Department of Business and Professional Regulation. That's going to cost our homeowners anywhere from $25,000 to $35,000, depending on who you talk to. aside from going to binding arbitration with the department, what are our options to force this board to hold an election?
Well, I mean, if you're a 720, I don't see how, you would have any basis to pursue any complaints with the division, right? I mean, except for maybe election challenges. So,
Election challenge.
recall could be a potential a recourse. Try to recall the existing directors. Okay, and that can be done, with or without cause by vote of the majority of the membership. And that can be done, through written agreement, or if your bylaws allow for a recall process at a membership meeting. So check your bylaws, and if there's authority for that, then upon a petition of the membership, you can seek to recall directors at a membership meeting. Short of that, I would think your recourse would be to file a legal action in court against the association. But those are my general thoughts based on the sort of general information you've provided.
Does that help, caller?
Okay. Yes, it helps. We attempted a recall about 2 years ago, but unfortunately, with the builder building these lots, every time we reached a certain figure, then we had to reach out, and get more recall votes. So, and then, as you know, these recall ballots expire after 90 days, and then we had to go back to individuals to recertify the recall. I don't believe our documents call for a recall process at a membership meeting, but I will look into that. We're trying everything we can short of filing legal action, but I believe that and correct me if I'm wrong, we do have recourse with the department in regards to the fact that they have violated our declarations that call for an annual meeting and election. We have officers that have a 1-year term, and they have violated all these agreements. So there's nothing in the law that we know of that we have found that says, well, if there's a builder dispute, they do not have to have an election. We have found nothing so far.
Yeah, I mean, yeah, unless there's something in the governing documents, which I'm not aware. You're correct. Yeah. There should be an annual meeting every year.
Okay, let's go to our next one. We've got Joe. Let's bring up Joe, Rebel. If an owner of multiple condo units is delinquent in assessments for one of them and has leased all of the others, can the association direct all rent from all tenants to be paid to the association?
Okay.
I don't know if I understand.
So it sounds like this this caller has multiple owns multiple units, rents all of them, but seems to be delinquent on only one of the units. I mean, if that's the case, the association should be sending a rent demand for the delinquent unit, and then using the rent paid from that delinquent unit to pay any delinquent assessments just on that particular unit.
Okay. By the way, if you are calling in and you get a busy sound, or maybe it goes to voicemail, keep trying. We get a lot of calls for this show. Don't give up. The show is 50 minutes long, and we should get everybody in. Kirsten, let me ask you. I just want to make sure people realize you have offices in Tampa, Orlando, South Florida in Pompano, and also in Palm Beach. Did I leave any out?
No, that's all the offices in Florida. Yeah.
Yeah, and
Pompano,
so
Palm Beach, Orlando.
yeah, and now probably in the next 10 minutes, we're going to give you a rundown of classes that is so amazing. You all offer free classes all month long. You give your time to educating, and plus coming on the show like this. Uh, Hats off to the firm.
Yes, Steve, we do. We definitely do a lot of seminars. A lot of them are webinars. So,
Yes.
board members and owners can appear, online out of the comfort of their own homes. All of these seminars, webinars are for free. And most of them are about an hour, with the exception of maybe our board certification classes for both, condominium and HOAs, which takes about 2 hours. And we also typically offer, a Q&A at the end. So we stick around to answer any additional questions from listeners that we might not have answered during the show.
Okay.
So I definitely encourage everyone to go on our website and just, check out all the new seminars coming up this month.
I'm going to go to a text we got from Guy. He wanted to know, what should a buyer do to make sure the sellers don't know any assessments?
Well, if you're a buyer of a unit, you definitely want to have, and this is typically done by the title company, you'll want to have an estoppel sent to the association so that the association can identify any outstanding assessments, whether it's regular assessments, any special assessments that are delinquent or coming due, and certainly any violations. So that would be the best avenue to determine whether there are any delinquent assessments out on the unit prior to buying.
Okay, let me go to the next question. If a condominium doesn't waive the structure integrity reserves for 2025 budget, must they start funding their structural integrity reserves in 2025, 2026?
Just rereading the question here. So my understanding is correct. If you adopt a budget after December 31st of 2024, then you have to fully fund the structural, the SERS funding. So you would be funding it for the year, yes, 2025. But you have up to December 31st of 2024 to present the option of waiving or partially fund those SERS reserves to the membership. And presuming the membership waives it appropriately and the board adopts the budget before then you still have essentially 1 full year that you can go, get away with not funding those SERS reserves.
Great. Okay, let's go to Stan on the phone. Good afternoon, Stan.
Good afternoon. Our board is calling a meeting tomorrow to elect an officer and discuss 2 minor items, and then they intend to adjourn the meeting. Our bylaws indicate the meetings must include unfinished business, new business. Can the board just adjourn the meeting without going over those items?
Stan, please turn the radio off behind you.
Stan, turn the radio off in the back.
Is that your shoulders?
Okay, I think that's better.
If Stan, could you repeat your question?
Certainly, the board is having a meeting tomorrow to elect an officer and 2 minor items, and then they intend to adjourn the meeting. That's the entire agenda. Our bylaws indicate at a board meeting, there has to be going over unfinished business and new business. Can the board just adjourn without doing that?
Now, do the bylaws absolutely require all these agenda items, or is it, sometimes bylaws identify, proposed agenda items?
I'm looking at the order of business in our bylaws. And it includes in the order of business at a board meeting, unfinished business and new business.
But is it written, as a mandate, or is it a shall or a may?
Shall be.
Well, then it sounds like the board should have, it sounds like the board, maybe should have identified those additional items as agenda items on the notice. Now, having said that, is anybody going to legally challenge that board meeting because certain agenda items were not disclosed?
Me.
I think if the board doesn't want to follow the strict agenda that's set forth in the bylaws, then perhaps they may want to consider amending the bylaws to give them a little bit more flexibility on designate agenda of future board meetings.
So at this meeting, do they have to go over those items?
Well, the notice doesn't identify those items as agenda, so they shouldn't be, right? They should only be going over items designated as agenda items on the notice. Is it a technical violation of the bylaws that they didn't identify the other agenda items, the unfinished business? Perhaps. But it's probably unlikely that any owner is going to legally challenge that board meeting because it didn't include these designated agenda items. So, my suggestion is go ahead.
No, I'll listen to you.
No, my point is if the board doesn't, want to follow the order of business that's identified in the bylaws, then they should consider amending that portion of the bylaws to get rid of that requirement.
Okay. Another quick question. Do the officers of the company, of the HOA, have to be directors?
That is a very document-specific question. So you'd have to look at your governing documents to see what they say. Look at the bylaws and see if officers are required to be directors. Sometimes they do. Sometimes only certain officers have to be directors, but that would be specific to your bylaws.
Thank you for your time.
Sure.
Thank you. We're going to go to our first break, Kirsten. Give everybody the phone number at your office where they can reach you at.
Yes. So the main office number is 954-928-0680. And, that's the Pompano number. But if you call that main number, our receptionist will certainly direct you to any attorney in any other office in the state of Florida. So.
Beautiful. We're going to go to break. When we come back, we're going to go over some of those seminars that are coming up next month. We'll be right back with more Ask the Experts.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800 974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the Ask the Expert show. We're with you every Tuesday at 5 p.m. And that is Eastern Standard Time. And if you would like to write into a show, if you'd like to call into the show, you're more than welcome. We're here with the K. Bender Rimbaum Law Firm, the Community Association Law. We're here with Attorney Kirsten Henza. Kirsten, do you have the schedule of what's going on? Classes for next month?
I sure do, Steve. I sure do.
Oh, good.
And by the way, this is something that the listeners can find on our website. But essentially, let's see here. I'm teaching a condo board certification class on Thursday, February 15th. So any listener or anyone that you know who just joined the board of directors, they're encouraged to attend this meeting. It's 2 hours and it's going to be via Zoom. We also have an HOA board certification class on Tuesday, February the 20th. And that one is taught by one of our attorneys from the Palm Beach office. Let's see. We have another condo board certification class actually at the end of the month, taught by attorney Andrew Black, who's with our Pompano Beach office. And we have a CAI Central Florida trade show coming up on Friday, February 23rd. Attorney Alan Schwartzide, who is the managing attorney of our Orlando office, he will be at the Orlando Expo, and he will also be presenting a class on covenant enforcement. That is for 1 CEU credit. Also, for those who are here on the West Coast in the area, the Tampa Trade Show is also coming up on February 9th. KBR is actually going to be at the trade show, and we will be at booth 300. So if you are planning on attending, feel free to stop by at our booth. It's booth 300, and it's going to be again February 9th. And I'm actually going to be teaching 2 classes at that trade show. At 9:30, I'll be teaching the class on updating your governing documents. We will be talking about amending the governing documents, the process, and some key provisions that you might want to look in your governing documents to see if they need to be amended to better protect the interests of the community and the association. And then in the afternoon at 2:30, I will be teaching the legal update. Okay, these are all the legislative changes that took effect July of 2023. Okay. So I encourage everyone to stop by.
Wow, we got a lot of questions here on our board. Let's go to Karen. Can a condo board have a boat or vehicle moved out, ask owner to pay for it if they're not in working condition and they've been given numerous warnings?
All right. Well, a couple of things. First, check to see what authority you have with respect to those types of vehicles. Typically, you'll find authority regarding vehicles in your declaration of condominium. There should be some provision that identifies the type of vehicles that are prohibited, which may include vehicles that are in disrepair. Alternatively, you might have authority to adopt rules regarding these types of vehicles. That's something you'll have to check your governing documents, but presuming there is some kind of authority in either your declaration or in your rules to for the association to control vehicles, then you should have the ability to enforce these vehicles restrictions. One way is through towing. Okay. And typically that would be at the cost of the unit owner. Okay. The association would have to enter into some kind of towing contract. And there is a statute that governs, towing, and specifically the type of notices and the type of signs that you're going to have in your community to make sure that you're in compliance with Florida statute before you start towing. So you'd want to make sure that your legal counsel reviews any contract that you're considering and entering with a towing company.
Okay, let's go to Joel. Let's get his question up there. Can a prior board member use a list of owners' emails to disseminate unsolicited political propaganda type messaging?
Well, I mean, if owners have provided their email address to the association for purposes of receiving official notices of association or board meetings, then those emails are accessible to owners, really, and any board member or any owner has access to those emails. They can just request to have an inspection of records and obtain a copy of these emails. In which case it would be, appropriate use of those emails. Unfortunately, if a lot of these emails were not provided for purposes of, receiving official notices from the association, then they're not accessible, right, to owners, and shouldn't have been used by this director to disseminate, political propaganda.
Great. Let's go back to our telephones. Marvin is on the line. Good afternoon, Marvin.
Yes, how are you?
Good.
I live in a condo down in Fort Lauderdale, and I've got a couple of related questions. A new board has now taken over, and first thing is they've decided to impose move-in, move-out fees, as well as fees for the use of common elements and amenities. Is that legal? And secondly, is there any recourse if they fail to take a board member certification course or sign a declaration that they read the condo docs?
Okay. All right. So as to the first question, move out, moving fees, is that, for owners or renters that are moving in? Is that what these
Anybody
fees
moving
relate
in
to?
and out.
Mm-hmm.
Yes.
And I presume these are
But-
to cover any damage to the common elements, right?
No, it's a non-refundable fee in addition to a security deposit.
Okay.
The security deposit is refundable. The fees are not.
Right. Well, and there should be authority in your governing documents as well to collect a security deposit in connection with a lease. But for non-refundable, move-in, move-out fees, my opinion is that really for best enforcement, that should be something that should be set forth in your declaration of condominium. So if it's a rule, yeah, I mean, if it's a rule, that's potentially, challengeable. In terms of, charging a fee for use of amenities, I mean, under the statute, the association has the ability to charge a fee for exclusive use of amenities. So typically, if an owner wants to rent a clubhouse, right? Or, reserve, a conference room, for a particular event, and it's just for the exclusive use of that particular resident, then the statute, allows the association to charge such fees. Other than that, it would have to be there would have to be some authority in your declaration to charge for those amenities.
Okay.
And then
And if
your
there's nothing
second, I'm sorry.
Yeah, the second question is no one's taken a course or signed the affidavit that they read the docs. And the last board also passed a code of conduct for all board members, which has to be signed within 30 days of their obtaining office. And none of the board members have signed it. So is there any recourse?
Well, the recourse is that, well, first of all, right, they have the option to either attend a division approved course, or the easier option really is just to review the governing documents and then sign some certificate saying that they have read and the governing documents, and will, work to their best of their ability to uphold the governing documents. That's the easiest, right? Just sign it, keep it as part of the official records. Otherwise they're deemed basically, suspended off the board. So they need to get this done ASAP.
Time are they deemed?
They have 90 days. They have 90 days from the date of being elected or appointed to get this done.
And if they don't, they're automatically suspended?
Right.
Until they file it?
That's correct. That's correct.
Okay. And
so
what about failure to agree with? What about failure to agree to a code of conduct that has to be signed by board members pursuant to a resolution passed by a prior board?
Well, that's a little bit tricky. There wouldn't. It depends on if you have anything in your governing documents that may address that and potentially, deem it as a resignation from the board if they haven't signed that code of conduct. I suspect not. So it doesn't seem like that would be a basis to, recall them or get them off the board.
Yeah. Okay. All right. Thank you very much.
Calling.
Very helpful.
Good. Well, we got a crazy day today. Let's go to Roger. He said, if HOA attorney has a retainer agreement for hourly rate, can hourly rate be increased by the attorney with the board approval? No references in retainer to increase. Is a new retainer required with the board approval?
Yeah, I mean, you don't need board approval for a law firm or legal counsel to increase their retainer fees. But it depends on what that retainer said initially in terms of any increases or any modifications to their agreement.
Okay, let's go to Ocean. Can an HOA board still waive fully funding of reserves without a vote at the entire community
So it's a little bit unclear whether by HOA the caller meant condominium board or a homeowner association board under 720. And let's just say we're not talking about CSRS. We're just talking about just regular reserves. No, waiver of reserves, it's still for condominiums. The statute still requires membership vote in order to waive reserves. Okay.
720.
720. With 720, it's a little bit different than in a condominium because with 720, essentially the membership needed to have approved statutory reserves in order for them to be, protected reserves under the statute. And if the membership voted to approve statutory reserves, then under 720, they have to be funded and waived in accordance with the statute. And the statute under 720 requires a membership vote to waive those types of statutory protected reserves. If by reserves, the caller means, discretionary funds, and not reserves that were approved by the membership, then they're not statutorily protected. And so then they don't have to be funded or waived in accordance with the statute, which means that the board has discretion to, fund or waive them upon a vote of the, majority of the board. So I would say to the caller, check your official records of your community, see if there's any record of the membership having ever established these reserves as statutory. Okay, if so, then you have to waive them in accordance with the statute, which requires a membership vote. Otherwise, then it's just a board vote.
Okay, let's go back to our text messages. Debbie, she said, I'm a board member. We have residents playing pickleball. Kirsten, we're getting a lot of letters about pickleball. She wants to know, we are playing in an unused parking lot area. Are we as a board liable?
So these owners or these residents are playing pickleball in a parking lot that's not used, just kind of a vacant space. And I'm sure that parking lot hasn't been designated as, for pickleball, or I'm going to have to assume.
I'm sure.
Which, by the way, I am intrigued by pickleball, and I actually want to take it up as a sport.
Have you started playing?
No, I haven't, but it looks so fun. So fun. I mean, first of all, it doesn't sound like playing pickleball in an unused parking space or parking lot is a safe choice. I think the first thing, and then there's potential, liability exposure to the association if that hasn't been designated as a pickleball court. So, I would say take a look at your governing documents, see, what, if anything, it says about the use of this parking lot. See if you have documentary authority to adopt rules regarding, common areas. And you might want to, adopt a rule, at least prohibiting the use of pickleball in that space, because it doesn't seem like a safe choice. And then I would certainly contact your insurance agent to just make sure that you have proper insurance coverage in place and, would protect the association in case someone injures themselves playing pickleball.
Okay, let's go to our next chat line. If proxies were passed out door to door 1 week before they were mailed out to the 720 HOA by a rogue board member, would that negate the election?
Can you pose that question again, Steve? So I can take a look.
Can we bring that back? Here you go.
Yeah. It's a little bit. It's a little bit of a convoluted question here. Not clear if they mean the proxies were mailed out with the notice of an HOA election, but this board member ended up, I guess, knocking, on doors, collecting proxies. I mean, there's nothing in the law that prohibits, someone collecting proxies, right? The question is there something in the bylaws of this community that prohibits the number of proxies, for example, that this board member can show up at the meeting, right? So if the most that you can bring to this election is 5 proxies and this board member shows up with 10, well, 5 is the most that he can use towards the election. I don't know that would necessarily negate the election.
Okay. We'll leave it right there. Let's give everybody the phone number again.
Yes, the main number is 954-928-0680.
Let me go to Art. This is, are there new condo law bills coming up regarding being certified, and will it keep people running to be a board member?
I mean, I'm not aware of anything, any changes to that. I mean, the requirement as of now still stands. You have 90 days from the date of the election from the date that you were elected or appointed to the board to do either the division approved course or sign a certificate that you have read your governing documents and you're going to try to the best of your ability to uphold them.
I'm going to try to, let me see. I think we have, okay. I'm going to try to see if I can get this last question in. It says, elections ended up with more ballots than voters, so a new election scheduled, but they never had an additional election. Is there a 60-day limit from the date of the election? We are a condo, we never did a new election, and we are now past the 60 days.
It's a little bit of a confusing statement question.
Well, I'll tell you what, I will have them, because I'm sure they're listening, maybe write in a little bit clearer. We try to present the questions exactly the way you give them to us. And sometimes we have to decipher exactly what you mean. And, it's really important to let us know if you're a condo or an HOA, because it does make a difference. Let's do one more time. Give everybody the website and the phone number again, Kirsten.
The website is kbrlegal.com, and it has just so much information on there. Course materials, our calendar. We have archived many of our prior seminars and webinars, and even these live radio shows. So definitely encourage your listeners to go on our website. And the main number to our office, which is the main number to the Pumpkin office, is 954-928-0680. And, caller calls there and you get connected to any other attorney in any other office.
Kirsten, you are doing so good. We love doing your show. Kirsten will be back again with us next month on the Ask the Expert show. Thanks again, Kirsten. Have a good week. Stay warm. We'll see you soon.
Thanks, Steve. Bye-bye.
That's Kirsten. What a great attorney she is. Anyhow, that's it for us today. Thank you for all your participation. What a great day. We were filled up. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.